Hello, this is Naima Stevenson Starks. Happy to be joining you virtually today as you all are going to have a discussion related to the task force that's looking at enforcement infractions related issues in Division 2. As a, kind of as a precursor to that discussion, the team thought it would be good for me to make a few brief remarks just on the history of how we got to where we are, where you all will be kind of evaluating that infractions enforcement landscape in Division 2. So I am our Vice President of Hearing Operations. I assumed that role back in June of 2019, so almost a year in now. I have the staffs, the pretty incredible staff within the national office that support the adjudicative function of the infractions process, the Division 2 Committee on Infractions and the Division 2 Infractions Appeals Committee. Both of those staffs report into me in this newly created position. And I also work with the newly created independent accountability resolution process that is only at this point in a creature, so to speak, of Division 1, and that is a new process that became effective August of 2019. So with respect to this issue, in the summer of 2019, the Division 2 Management Council reviewed data related to major infractions cases in the division, and there appeared to be a little bit of an uptick in the number of cases. So that prompted a discussion as to whether or not there should be some evaluation of the parameters of the infractions process, and particularly looking at some of the things that have been introduced over the course of the past several years in Division 1 to see if any of those processes, tools in the toolbox, so to speak, would be appropriate for Division 2 to at least consider whether or not embracing some of those would be, a good thing for the infractions landscape in Division 2. One of the things that I know you'll hear from the team that will describe some of the work that has been done to date is that in Division 2, many of the cases, even though there's been more cases, many of those cases have been self-reported by institutions. So that's a positive thing because our peer review infractions model is really predicated on collaboration and self-governing and self-policing to a certain extent. So that means that the system is working. If institutions monitoring systems are detecting and institutions are then reporting, any violations related to NCA rules, then that means that the system is in fact working. But it always can be improved, and that's really what the task force was looking at. So the task force was the council established the Enforcement and Infractions Task Force to review the infractions process. And the council charged the task force with studying changes that I've alluded to in the Division 1 framework to see if any of those would be appropriately applied in Division 2. The changes in the Division 1 landscape really came from two different processes. One was the Enforcement Working Group initiatives, and that's where the process in Division 1 moved from secondary and major, which was kind of that binary, just two levels of violations, to a more tiered structure where you have level 1, level 2, and level 3. sets of violations, level 1 and level 2 being those that are described as the greatest threats to the collegiate model, and level 3 violations, which are primarily handled by the NCA enforcement staff, are those that don't necessarily result in a significant, competitive recruiting advantage, and some of the other things that the rules are really designed to prevent. So we had the leveling change as a result of the enforcement working group. And then we also had a penalty matrix kind of created where depending on the level of the case and whether or not that level was aggravated or mitigated by certain factors that were identified by the enforcement working group in Division 1, then the penalties would be laid out on this matrix that would provide some transparency as to what penalties you would be possibly held accountable for depending on the leveling of the cases. So that was all really the byproduct of the enforcement working group that, occurred several years ago. And we're living in that world in Division 1 with those changes really playing out in the infractions process. And then more recently, as you all may know, we've had several recommendations across the association with respect to the Commission on College Basketball. And some of those did get adopted with respect to the infractions process, in particular in Division 1. One is the negotiated resolution concept. So that's kind of when the enforcement staff and an institution and involved individuals basically agree on not only that violations have occurred, but the penalties that should be assessed. That is still reviewed by the Division 1 Committee on Infractions, but ultimately that's an agreement between the parties, so to speak, and it's a way to more quickly and expeditiously resolve cases where there's not really a dispute with respect to what has occurred, and the institution, being willing to take accountability, and involved individuals in some instances being willing to take accountability for those actions. And then we also had, as I mentioned, this creation of an independent process. So instead of our peer review, where there's commissioners, athletic directors, and those connected with member institutions making the determination on whether violations occurred and what penalties assessed, as is done on the D2 Committee on Infractions. Now in Division 1, you have the D1 Committee on Infractions and that peer review model, but you also have now this independent accountability resolution process where there will be individuals untethered from Division 1 member institutions or any NCA member institutions who will be making those determinations. So those are a couple of things that have changed in the Division 1 landscape. And one of the things that the task force really wanted to look at is as to whether any of these changes that have happened over the course of the last several years would be appropriate to be considered in Division 2. The work has been robust since last summer in that regard. And as part of the first phase of review, the task force has preliminarily supported concepts that would enhance the legislation in 3 main areas. One is tools to facilitate cooperation of parties within infractions matters in Division 2. The second bucket is the use of information in decision making, including importation of facts, which is another thing that is a newer tool, so to speak, available in the Division 1 process to import information that would come from other proceedings into our NCA infractions process. And then finally, the negotiated resolution process and whether or not that would be something in Division 2 that would be useful, particularly since there's such a high rate of self-reporting, whether or not institutions might benefit from a more expeditious way of resolving infractions matters. So those are the three main areas that the task force has supported, at least at this point, and that you will be getting a little more information on from our wonderful staff, some of the folks in my area in hearing operations, but also on the enforcement staff as well, that will be going through a series of slides with you coming up. So as a housekeeping matter, we ask that you complete a brief survey to provide your feedback on these concepts. The task force will review this feedback at one of its upcoming meetings. And then I will stop there and introduce Laura, Ken, and Joyce, who will provide additional information. And I think it'll start off with Laura. So appreciate the time, and you all have a great day.
Hello, my name is Laura Wirtz-McNabb. I'm an Associate Director with the NCA Enforcement Staff. As Naima just shared, Ken Kleppel, Joyce Thompson, and myself will share the Task Force 6 concepts. I'm going to share the first two of the 6 concepts forwarded by the task force. The first concept is full cooperation. Currently in Division 2, bylaws 32.1.3 and 19.01.3 address the membership's requirements and definition of cooperation. Specifically, all individuals subject to NCA rules have an affirmative obligation to assist the enforcement staff, the Committee on Infractions, and the Infractions Appeals Committee to develop full information of infractions. Additionally, member institutions have an obligation to protect the integrity of an investigation. In an effort to assist member institutions in understanding how to meet their obligations of cooperation, a more detailed legislated list of what may constitute full cooperation could be adopted. The task force believes that the 7 bullets included in this slide, such as timely participation in interviews and providing complete and truthful responses, address circumstances where an institution and/or an involved individual can assist in the fair, accurate, collaborative, and timely investigation and processing of major infractions cases. This legislation could help promote transparency regarding cooperation, as well as help educate parties on the level of cooperation that is expected of them in the infractions process. As noted by Naima, you will be asked to provide feedback through a survey at the end of this presentation. So one of the questions you will be asked is whether Division 2 should adopt legislation that includes examples of what constitutes full cooperation. The second concept forwarded by the task force is about the potential ramifications when an institution or individual fails or refuses to produce requested materials or to participate in an interview. Currently, Division 2 bylaws 10.1 and 19.01.3 require current and former staff members and prospective and current student athletes to furnish information when requested by the enforcement staff. If those individuals fail to produce information or participate in an interview, the enforcement staff may allege a failure to cooperate and unethical conduct violations, and the Committee on Infractions may find those violations occurred. The task force believes the adoption of this legislation that expressly permits the Committee on Infractions to infer that the failure is an admission that the alleged violations occurred may help facilitate cooperation in investigations and provide transparency for the Committee on Infractions decision-making process. I am now going to hand it over to Ken to talk about the third concept.
Thank you, Laura. My name is Ken Kleppel. I work with the Office of the Committees on Infractions matters across all 3 divisions, and I'm excited to work with the task force, councils, and membership on this review of the infractions process. Laura has talked about 2 of the 3 possible legislative changes supported by the task force and recently adopted in Division 1 to expand the toolkit available to the enforcement staff when it investigates cases. The third of these possible legislative changes addresses whistleblowers. Division 2 legislation does not expressly protect individuals from retaliatory action by institutions when they report information about potential NCA violations. There have been times during investigations when individuals have expressed an interest in sharing information with the enforcement staff about potential violations, but raised concerns that their institution could possibly take action against them for doing so. Modifying the legislation to expressly prohibit institutions within the context of infractions cases from retaliating against staff members, prospects, or student athletes who report information about potential violations helps address this concern and may prompt individuals to come forward. Note that this legislation would only make institutions answer to the NCAA for retaliating against whistleblowers. It does not defend individuals against any employment action that may be taken by an institution against them, nor does it supersede any state or federal legislation regarding whistleblowers. Those are separate matters. It is also important to note that Division I adopted this whistleblower protection in 2018 in direct response to a recommendation by the Commission on College Basketball to include the specific protection in Division I legislation. So defining what constitutes full cooperation, expressly permitting the Committee on Infractions to view a party's failure to cooperate as an admission that the alleged violation occurred, and whistleblower protection are three concepts for consideration that would expand the toolkit available to the enforcement staff. I'll now turn to Joyce to talk about concepts supported by the task force that address the use of information in decision-making by the Committee on Infractions.
Thanks, Ken. I'm Joyce Thompson, Director of the Infraction Appeals Committees. As it relates to concept number 4, the importation of facts, the importation of facts bylaw became effective in Division I in August of 2018. Bylaw 19.7.8.3.1 is an infractions processing tool that allows the enforcement staff and the Committee on Infractions, and now the Independent Resolution Panel, to rely on decisions that are not under appeal from various courts, accrediting bodies, and other administrative tribunals. The evidence submitted and the positions taken in these proceedings by parties can now be weighed and considered in the infractions process. This process should allow the enforcement staff, the Committee on Infractions, and the Independent Resolution Panel to make fully informed charging and processing decisions and have access to all the available information in an infractions case. Finally, what I will say about this bylaw is that the use of this tool would allow the adjudicative bodies to question institutions and involved parties who make contrary positions that are different in proceedings that relate or are germane to infractions matters. Now I will transition to concept number 5, which is circumstantial information. Before bylaw 19.7.8.3 was implemented in Division I, the legislation did not expressly permit the COI to use both circumstantial and direct information. Clarifying the information in this bylaw makes the infractions process more efficient and more transparent for the membership. This concludes my presentation on circumstantial information, and I will now turn the presentation over to Ken to discuss the negotiated resolution process.
So we've talked about tools to facilitate cooperation and use of information decision-making. The last area of possible legislative change supported by the task force is a negotiated resolution process to resolve cases. Under the process discussed by the task force and now legislated in Division I, the enforcement staff may negotiate resolution of cases with an institution or involved individual when the parties agree on the facts, violations, and penalties, subject to review and approval of the agreement by the Committee on Infractions. This would be a new track, a third track for resolving infractions cases in Division II. There's currently the hearing track, where there is no full agreement on the facts and violations, and the matter proceeds to a hearing. A summary disposition track, in which the parties agree on the facts and violations, but not the penalties, and submit a summary disposition report to the Committee on Infractions for review and approval, and for the committee to determine what penalties should be prescribed. And now a negotiated resolution track, where the parties fully agree on the facts, violations, and penalties. So let's talk about some of the elements of negotiated resolution discussed by the task force that are currently legislated in Division I. First, The Committee on Infractions will only reject a negotiated resolution if it's not in the best interest of the association or the agreed upon penalties are manifestly unreasonable under the legislation. An example of a case not being in the best interest of the association is if it is an extremely high-profile case with layers of issues that the committee may want to review via another track. An example of a penalty being manifestly unreasonable is if the penalty falls outside the core penalty guidelines, which are required ranges for penalties in Division 1 based on the level and classification of the violations. Note that Division 2 does not currently have core penalty guidelines, but rather a list of penalties available for major violations. Second, there are 3 options for the committee when it reviews a negotiated resolution. The committee can approve the agreement, it can reject the agreement and move the case forward for processing via summary disposition or hearing, or it can request additional information or clarification from the parties and ask for an amended negotiated resolution. Third, negotiated resolutions are final, not subject to appeal, and have no precedential value. Finally, negotiated resolutions are released by the NCA to the membership like other infractions decisions. Over the past year, the Division 1 Committee on Infractions has processed and approved 14 negotiated resolution agreements. That's about 1 in every 2 cases that have been processed by the committee over this time period. These cases have been processed in an extremely expeditious manner. There are roughly 5 days on average from final COI review of the agreement to release of the agreement to the public. Now, the negotiated resolution provides several opportunities for Division 2. It could create efficiencies in the resolution of cases like we've discussed. In fact, there was an appetite for this within the Division 1 membership, where institutions and individuals wanted a way to more quickly resolve cases when there was agreement on the facts, violations, and penalties. In addition, by being able to negotiate with the parties, negotiated resolution gives the enforcement staff another tool to obtain concessions or additional information from parties during the investigation. So that's negotiated resolution, the third broad concept supported by the task force. We appreciate the opportunity to present these concepts to you. The link to the survey, as well as a link to a corresponding handout that summarizes what we've discussed, has been sent to you in conjunction with this webinar. We ask that you complete this survey. The task force will review your feedback as it concludes its first phase of a review and begins additional phases related to other areas of the infractions process. In the meantime, please reach out to us with any questions. Again, thank you.